Ya Ali Madad, from wherever you have joined us today, thank you very much for your interest and support in the series of programs that the Ismaili International Conciliation and Arbitration Board, which I am enormously privileged to chair, broadcasts on Ismaili TV during Mediation Awareness Week. Our objective in presenting these short video vignettes is twofold. Firstly, we want to bring awareness to the services of the conciliation and arbitration boards, affectionately known as CABs, that function in over 20 countries across the globe, providing murids and others amongst whom we live services, mediation services, so that they are able to resolve their disputes peacefully and within the ethics of our faith. We all know that conflict is incredibly expensive. It's costly. It's costly not only financially, but costly emotionally, and with the harmony within our communities and our families. So the CAB system is designed to help Marids deal with matrimonial, family, and commercial matters discreetly and confidentially within the ethics of our faith, following the laws of the countries in which we live. Our second objective is to present insights and ideas around dispute prevention. This particular conversation will be about mediation itself and the importance of having an open mind in how we address our issues as they come forward. So I'm really pleased to have the opportunity for a conversation with Justice Halim Dhanidina. And it is particularly nice that Justice Dhanidina is a member of our Jamaat and an American lawyer, a former judge. He has just recently retired from the Court of Appeal and does work now with another organization as a neutral. But he brings to us almost 10 years of experience as a judge in the courts in California. He's the first Muslim to have had that position of a judge in California, which is an incredible honor for him, but also, of course, for us as fellow Murids to have great pride in the fact that someone in his capacity has managed to get to his capacity. So it's really a great pleasure, and I'm looking forward to our conversation. Justice Dhanidina was graduated from the University of UCLA, did his JD at UCLA, and was appointed as a judge in 2012, and then as a Superior Court judge in 2018. So he has had a service for many years as a judge. But he also served before that as a prosecutor. So he brings that experience as well from many years of that. I think he practiced for that for about 14 years. So you bring to us the experience from the judicial branch, which I recognize is different from mediation. Definitely agree to that. But when we deal with mediation services, are also always saying how we work within the shadow of or within the parameters or the boundaries of the laws of the country. And that is set by the judiciary. So you as a judge are able to provide us with the kind of insight that Murids would find very helpful as they assess the relative merits of the forum that they need to choose to resolve their disputes. But before we go into that, I would be really pleased to hear from you your journey to becoming a judge, because that is, I find judicial positions are the sort of pinnacle positions within any society. and to have the ability to have taken that position is a very special honor, but of course comes with a lot of hard work. And so it would be really great to have you first of all talk to us about your journey to becoming a judge, and then we can talk a little bit more concretely about how your experience helps shed some light on mediation services overall. So over to you.
All right. Yes, absolutely. Thank you. And Yalima, thank you for having me. As you mentioned, my first legal job after graduating from law school was with the district attorney's office in Los Angeles. And for people who don't know, the district attorney, in essence, is a lawyer in criminal court who works on behalf of the government to prosecute cases. So when someone is charged with a crime, the district attorney appears in court and presents evidence, kind of like what you would have seen on television or in the movies, to demonstrate for a jury that a certain crime has been committed. And so I did that for 14 years, handling all types of cases that you can imagine. Ultimately, a lot of violent crime. Los Angeles has had an issue with violent crime over the years, and so I handled a lot of cases involving street gangs and other types of homicide crimes. And my career actually was going quite well there. Uh, Eventually, I got to a point where I decided I needed something different. Um, at that point in my life, I had young children, and the stress of being in those types of cases all of the time started to wear on me. And I was advised to apply for a judicial position. And in California, in the Superior Court, those positions are filled either by appointment through the governor's office or through election, just depending on when in the cycle you are seeking the job. And so I applied for a judicial appointment through the governor's office. It's a fairly extensive application. It actually took a few years from beginning to end. And ultimately, the governor, Jerry Brown at the time, appointed me in 2012 to serve on the Superior Court as a trial court judge. So, in essence, I was a judge in the same courtroom in the same types of cases that I had been an attorney in, now just in a different capacity. And there I stayed for another 6 years or so, presiding over trials, both civil and criminal cases, and then was elevated to the Court of Appeal. In California, we have a three-tiered system. So we have the trial court, we have the Court of Appeal above that, and then the state Supreme Court above the courts of appeal. And so I served on the Court of Appeal for about 3 years, where I reviewed in the neighborhood of 800 to 900 lower court decisions, basically making sure that there weren't any mistakes that were made that would require the cases to be reversed. And then I left the judiciary about 2 years ago to return to the practice of law. I handled civil litigation matters for about a year, a little bit of criminal defense cases, and then just recently, over the past few months, have left that behind to begin my new role as a neutral, where I sit in mediation and arbitration of disputes that are handled outside of the court system.
So you certainly have the breadth of experience for us to have this conversation around mediation services, because you're currently in the midst of doing that work. Before we kind of talk about the mediation part of it, are there any kind of key learnings, key messages, and key things that you think really propelled you in excelling in the work that you've done throughout your career so far?
Well, a couple of different things. Growing up, certainly as an Ismaili, I grew up in a household that was informed by our faith and our culture. And one of the key components I think all of us can agree on is, you know, whatever job you choose for yourself, you should become the best at whatever that is. And that's what you should always be striving for. And so there was a certain amount of work ethic, perhaps even ambition, to continue to rise and to excel in the field. And I think that definitely helped me. I never really became too content with any one thing, because I was always looking at how I could build upon that. The other thing, maybe perhaps more practical, is I began to realize very early in my career that the way you get the things that you want is often through collaboration and through relationships. And it's very important for people, even at the very beginning of their career, even if they're still students, to recognize the importance of relationships and to constantly be connecting with people. And that means sometimes helping people, uh, volunteering for things, trying to connect with folks who aren't uh, obviously even in your field. Because I find the wider your network gets, the more it serves you over time. And there really isn't any professional achievement that I've had that I can think of where I accomplished it by myself. It was almost always through the help and support of other people.
That is such wise advice, and certainly I think there's always this sense of having that generosity of heart, so that you are offering and you are receiving as well, and it is in that relationship that both happens together, and that we all thrive as we move forward. So that's really, thank you. That's really wise advice. Coming back to mediation and the work around that we do within the CAB system, we've always sort of told people litigation is expensive, judicial process is arbitrary. This one you have a sense of control over. From your many years of experience as a judge, if I were to ask you for some sort of key pieces of advice that you would give to people who are in the midst of conflict, what they should consider when they're looking at resolving or dealing with their problems overall, regardless of what the subject matter is about.
Yeah, I always try to tell people that the decision of to take a case formally into the legal system or to choose some alternative method of resolving the conflict, that's a choice, and that's a choice that's often informed by a risk management type calculation. Benefits and burdens. What are the chances that I can win? What are the chances that I will lose? And what's it going to cost? And I think far too often people focus on the costs of losing. That's not really, to me, the only consideration. Because then what happens is people will think, well, I've got a strong case. I should win. And so there isn't really much of a risk of losing. Here, I have a very strong position. But one of the things that I've seen is people should really give a lot of weight and time to considering the costs of victory. In the context of the court system, you can win. There's always a winner. There's always a winner and a loser, but oftentimes both pay a price. And you have to ask yourself: is the cost of victory worth its price? Sometimes I try to give the example of a fist fight. You can get into a fist fight with somebody, and you can be fairly certain you're going to win the fight, and it might be a long fight, but you might prevail. But at the end of that fight, what are your injuries? How badly bruised have you been? Uh, and that's a very real thing, especially because I have seen firsthand how even if you go into the court system and you win, uh, oftentimes those rulings don't last. They go in front of a court of appeal where they get altered, modified, or sometimes even reversed. As I mentioned, I handled nearly 900 appeals on the Court of Appeal. Every single one of those appeals involved somebody who thought they were done. And the fact of the matter is, they're not done. You're not done until the entire machinations of the justice system have concluded. And that is oftentimes years and years in the making, which causes emotional stress, stress on your financial resources, even when you win. So I think the takeaway is to consider the costs associated with winning.
That's really interesting. One of the things that we hear from individuals, particularly in family law matters, is they say, if I don't take this to court, I will not be able to demonstrate to my children that I really fought for custody for them, that I really fought for my time with them. And we're often trying to tell them that being able to demonstrate compromise is maybe not a bad thing to be able to show your children as well. So, how do you respond to something like that? What would be your views?
Well, yeah, I agree with you. I think modeling compromise is a good lesson for any child to learn. Also, perhaps the dissolution of a marriage, which is traumatic for any family, that trauma is exacerbated the harder you fight and the further you go into court. And one would have to ask, well, are you doing your children favors there? Beyond that, I would, in very practical matters, when you're dealing with a family law situation and splitting up a financial community, we talk about that sometimes as a pie and fighting over, which the size of the slice of the pie that you're going to have. And when you litigate a case to the hilt through the formal system, the lawyers are getting most of that pie, and very, very little of that pie will be left over for the children. And so at some point, you have to ask yourself whether that fight, even if it's in good faith because you want to demonstrate how much you care, at the end of the day, that fight may be causing more harm to the family unit and to the children in the long run.
From your experience, the court process, of course, is such a public process. There's a level of, as it should be. I mean, that's what a court system is supposed to do. And yet, sometimes having that kind of publicity undermines the dignity of people that are involved in that conversation. So, what are your thoughts about that?
Yeah, I think another key factor that drives people out of the formal court system is this desire for confidentiality, especially when you're dealing with very sensitive issues. It doesn't even have to be family issues, it could be business issues.
Right.
There's information that comes out in a proceeding that can be highly, highly sensitive. And once that happens in the context of a court proceeding, by law, that information is open to the public. Any member of the news media can look at a court file and determine what happened and publish it if they wanted to. Uh, in the context of a mediation or an alternative dispute uh, context, that's private and it's confidential. And so the how what the information people get about you and the other parties is confidential. um, and I think it also perhaps encourages better behavior because you are free to be honest and to be forthright, because everything in the context of mediation under the law is covered under a privilege. It's considered a mediation privilege. And so you can really get to the heart of the issue without worrying about posturing and how it's going to be received by other people who are paying attention. And so I consider that to be another key advantage.
Yes, yes, indeed. And from one a lot of the times one talks about, well, I will get a judge's order, and that will be an important thing for me to have. I will have a piece of paper that will make it possible for me to enforce it and deal with it. And there are occasional times when, of course, a court order is an important, it's an important legal tool and vehicle. uh, but over the years, I'm sure you've had experiences where those orders may not actually be implemented, right? And there are limits to your authority and power to do anything about that.
Yeah, enforcement is a key issue because if you obtain a judgment or a judge's order, enforcement is another hurdle. So whether it's the context of a business dispute, you may win the dispute, but then you still have to collect. And there are entire industries that are out there that are built around uh, trying to collect from people who don't want to pay, and people avoiding the collection process if they don't want to pay. And so it becomes just one more headache and drain on your emotional and financial resources. Uh, that's an issue. And I think the at the heart of the adversarial system, the court system, is that there's a winner and a loser, and there are very few losers that react to losing with contrition, right? They don't say, oh, well, I guess I lost. I suppose I was wrong. Now I'm going to do everything the opposite of what I've been saying. Very few people do that. There's a sense that the system let them down, or there's still that lingering bitterness over the dispute, and they will continue to fight. Whereas if you go into a voluntary system, whether it's voluntary arbitration or mediation, there is a much greater likelihood that any result is going to be achieved more quickly, but it's also going to be final because it's going to be achieved by consent. And when everyone agrees, albeit, they may not have gotten everything they wanted, but if they've all agreed at the end of the day, it will be much easier to move on. And I think that's something that cannot be achieved realistically in the court system.
Indeed. Thank you so much. This has been a very, very interesting conversation. And it's nice to get a reinforcement of what we have always been talking about, but from someone who really has the experience of having seen that over a 10-year career span of many thousands of cases that you would have dealt with. So I want to thank you very much for your generosity of spirit in sharing your knowledge and in supporting us through this Mediation Awareness Week. It's been a good conversation. Thank you very
Thank you.
much.
You're most welcome.
So for the Jamaat, I want to reinforce for you what we've said many times. Do not let your disputes fester because they have a way of growing. Know that there are within the Jamaat Imamat appointees who have taken on the responsibility, first of all, of training to be good mediators so that you can be assured that in whatever country you live in, you have access to the best in class services by a fellow Murid, and that service will be available to you at no cost. So really, there isn't a downside to at least trying the mediation process to get started along that way. Thank you very much for joining us today. From wherever you are, know that our prayers are there for your safety, your good health, mushkil asan, and immense barakah in your lives. Khuda Hafiz. Ya Allah.